So we're going to talk now about the relevant cases. This is Karen's. I'm deciding if we should skip it or not. I'll let her add her gloss onto it if she wants. So this is a case where I sat second chair with Karen. This is several years ago. And this is in Bridgeport. And so Karen is prosecuting a case of the case of Patrick Robinson, who is represented by a private attorney, not an SEA lawyer, that is very much, how would I put it, a frontier lawyer. He's got a
very aggressive and built better for the criminal system than an administrative unit.
Right. It felt like a criminal prosecution the entire time. So anyway, to set the stage, we're out there. We've done a lot of prep. Really good school board. Really good administrators. To start the hearing, Mr. Brenner stands up and objects to Karen prosecuting the case, saying that Karen is biased because she had exchanged emails with Patrick Robinson, who had actually emailed Karen to ask Karen if she'd represent him against the school. So Karen sends back the appropriate response from the legal ethics standpoint, saying, no, I represent the school. I'm sorry, I can't represent you. Please, don't contact me any further. Well, I'm sitting there, having not done all the preparation for the case, and watch him stand up and object. Basically, he says, Karen, you should have to go sit in the audience. You got another lawyer there that can do it. So I remember this case very vividly for that reason, if not other. But eventually, Tim Thompson, who's the hearing officer, says, no, Karen can prosecute the case, and away we go. So basically, here's what happened. During the 13-14 school year, they hired Mr. Robinson. And he had several incidents that popped up his first year. It became very clear to everybody that he was a bit of a different cat. That doesn't make him necessarily a bad staff member. But there was an incident that essentially happened on Veterans Day where he himself was a veteran. And so there was basically a dust up about whether he could park in the reserved parking spot for veterans that day. The administrator said, no, you need to move Mr. Robinson. That's intended for like the veterans that are going to come in as part of our celebration. We respect and appreciate and thank you for your service. But that's not the point of those parking spots. So there was, some dust up that related to that. Then there was this issue of he was leaving notes in a particular student's locker. And basically what they were is inside jokes, he called them. So it's that sort of, we're clearly not over the cliff. This isn't sexualized in any way, but it's strange enough that the administrators looked at that and thought, it's odd to have a first-year teacher putting notes, private notes in a student's locker, a high school student's locker. So they basically told him, stop doing that. He files a complaint with the administration saying they're targeting him. And eventually, in the second semester, they do look into that, resolve it, and say, okay, after investigating, talking to the students and everything, there wasn't actually anything inappropriate going on other than it looks a little bit suspicious, maybe a boundary violation. After that, because it significantly affects him, and to some extent understandably so, to basically have been accused of being a predator. And so that is repeatedly comes up in the documentation. I'm not a predator. Everybody's now targeting me. This false allegation has made me look different to everybody that I work with, and I'm just this first-year teacher trying to make it. So he starts retreating, refusing to meet, refusing to leave his office, and that stuff starts to intensify over the course of the year. Because of all of this, he files a complaint with the Bridgeport Education Association, with the Nebraska Department of Education, and he asked to meet with the school board to discuss the fact that everybody's been targeting him in February of his first year being a teacher. You want to take it?
I can. So he and his brother-in-law or somebody like that is an attorney, so I think he does have legal help. But he starts to submit these formal, very, very legalistic looking written complaints. Some of them he sends to the school, some of them he sends to the school's attorney. The school's attorney at that time tries to undertake an investigation and create some good paper for the district. But then there's a new sheriff in town in 2014, and the new superintendent, first off, everybody thinks that when they're the new administrator, they're gonna take this crazy employee and make them better. I can't tell you how many times I've had them say, well, now that I'm involved, okay. And sure enough, the new administrator tried to give this person a fresh start, but Mr. Robinson just wasn't having it. So in August, they have a meeting of the union because Robinson has filed a complaint with the Equal Employment Opportunity Commission saying that the union has failed to act to protect him. So the union meeting is not held at school, it's held in the city library. One of the people that's there is the attorney, Nick Welding, who's a good lawyer. And Nick does a great job. And the reason I know Nick did a great job is because I got to listen to the entire meeting because a teacher recorded the meeting. And you can hear her, we know who it is now, turn on the recorder. You can hear the fluffle, fluffle, fluffle as she puts it in her purse. You can hear her walking into the meeting, and then you can hear everything that everybody says. So Robinson has filed this NEOC complaint. Nick does exactly what we would do if we have a complaint filed. He stands up, he explains the process, and then he says, look, guys, you cannot retaliate against Mr. Robinson. You cannot treat him differently. You can't isolate him. You can't refuse to talk to him. You can't, say mean things about him. And the funny thing is, Robinson says that what Nick really did was tell the teachers exactly how to retaliate against him. Because he says, oh, everybody knows what the lawyer really meant was, here's a checklist of all the ways to retaliate. In this meeting, teachers are saying, look, Nick, we're scared of this guy. He's creepy. He is not normal. He's a weirdo. This guy had talked a lot about being a veteran. Did you talk about Veterans Day?
A little bit.
This guy had already pitched a fit because he didn't get special parking for Veterans Day. He's telling people all about all the stuff he did in Kabul and all these, like he's a sniper or whatever. I don't know that it's true, but the teachers are concerned that he's got these military skills. And so they start sharing with the union lawyer about what they're supposed to do. Nick does a great job and says, here's what I'm telling you, treat him the same, which is the right thing.
Be professional with him.
So this administrators, in the meantime, now we've got this war between the union and one of its members. We're just trying to, educate kids and keep everybody moving forward. So as the school year starts, they're trying to work with them. In the meantime, he's telling the principal and the superintendent that he won't come out of his office. He won't talk to any of them. They all are a lynch mob. They're all out to get him. We meet with him and tell him that he's not being effective. At one point, we give him his activities pass, to get him in free to all the school activities. He returns it, and then he sends this long diatribe email to the superintendent about how he would never come to any activity because Bridgeport sucks and the staff sucks, and he knows his rights. And after he returns the activity pass and sends this diatribe, we decide, and by now I'm involved, we decide this is enough. He's going to go on paid administrative leave because this is just untenable. Now, this is a brand new superintendent, and he's come into a district that has a lot going on. So you can see this is kind of a weird feature of this case. We put him on administrative leave in September, but we didn't give him notice of cancellation until February. We needed time for this superintendent to get to know his board. We needed time for some other pieces to fall into place. We also needed time for the teachers to stop being so freaked out. But notice there is no procedural violation from taking your time. Once you get him out of the classroom and out of the building, you can let everybody kind of catch their breath and decide if you're ready to go or not. Now, the bad news is you're paying him not to work all this time, but the good news is being deliberate about when you're going to issue that notice means that once you issue the notice and it's go time, you're ready to go. I think administrators should take advantage of this more often. I don't think we should be in such a hurry to give people cancellation notice. If you need to have time to catch your breath and get your ducks in a row, but you don't think they're safe in the classroom, or you think they're just so toxic to your staff you don't want them there, there's absolutely nothing wrong with putting them on leave and letting them sit there. This guy was a curriculum director, so we didn't have to hire a sub necessarily to replace him, but I've got no problem with hiring a long-term sub or a replacement teacher while they're on administrative leave. That's gonna be way less money than going to a hearing before you're ready. So we hold a hearing. I think this hearing was, let's see, we went all night and then stopped and took a little nap and then came back the next morning. So I think we had 26 hours of testimony, something like that. It was a fun hearing. We had armed law enforcement there. The community was there. It was a good time.
Karen ends up having to call the county attorney to testify as a surprise witness about the sufficiency of the Open Meetings Act. It was crazy.
It was so much fun. It was a great hearing. The lawyer also put his own, he didn't trust the court reporter because he said that we'd hired a bad court reporter. So he recorded everything with his own recording devices, including, I suspect, recording our private conversations at council table.
He set up a camera on the far side of the room and pointed it right at Karen, which is awesome.
It was awesome. I wanted to give him all kinds of special hand gestures, but I did not. So the board does the right thing, cancels his contract. Patrick Robinson appeals to the Nebraska Supreme Court. And the Nebraska Supreme Court did a great job. First, one of the problems, oh my gosh, make a note of this, because those of you that haven't looked at your policies, this is an issue that I worry about. The Bridgeport policy said, notice of our meetings will be made in a manner that has been determined by the board and recorded in our minutes, which is exactly what the statute says. But notice that that policy never says how you're actually going to notice the meeting. It becomes circular. And so that was, Bridgeport had that kind of a policy. It's really common all across the state. And so Robinson's attorney said that this was an illegal meeting because we never said how we were going to notice it. Now we had posted it in 3 places and put it in the paper. So that's why I had the county attorney testify, because he had personally seen the notice. So it showed that the public did get due and proper notice. But I don't like those policies that say, that don't say how you're actually going to notice the meeting. But we won that in the Supreme Court. They said the meeting was proper. One other argument they made was that the school district, the Board of Education can't use a hearing officer. The statutes specifically say that like Lincoln and Omaha can make personnel decisions based only on an attorney having a hearing and then that attorney telling the board about it. We can't do that in a class 2 or a class 3 district. But we still can use an attorney to advise the board. That's what the Nebraska Supreme Court said. It was a stupid argument from the beginning. I was never worried about it, but it's nice to have it be in black and white. This is the thing I think is the best information out of the Robinson case for the average district. Robinson said, hey, I demanded a meeting in front of the board in February. The fact that you gave it to me means that you were biased. And the Supreme Court said a teacher cannot bias a board by giving a board information and then later on saying that you can't fire me because you know what I told you.
And I think we would argue that this rule would apply to Cody's father-in-law.
Yes.
In the case where he shows up and yells.
Yes. Now we did in this case have every board member sign what's called a voir dire affidavit, something that says, I promise I can make my decision based only on the hearing evidence. And more, I think we're going to start using those just because the court here said, look, they all signed the statement, if that's good enough for us. So that was actually the issue I was most concerned about in this case. I always thought this argument was stupid, but the lawyer said, when you renewed his contract at the end of the 13-14 year, all the bad stuff from 13-14, you can't use that in 14-15. Like every year is a fresh start. Bobby's dad says, even a skipping stone eventually stops, right? And so what the lawyer was arguing here is that if you keep skipping, we can never use the past skips against you. And that's not what the Supreme Court said. They said you can look at the entirety of their history.
Which is significant in this case in particular because, and we'll get to some of their quotes because I think it's important to think about as an evaluator. But it also is important for the case of this teacher that Karen's talking about because that stuff, yelling at the umpires, I mean, if you can show that began a pattern 4 years ago of caring less about her professionalism, that may make it admissible. So winning this argument was bigger than it seemed because in a lot of these cases, like this hypo, you're going to want to look at stuff from past years to show that.
I had a cancellation hearing last year where a teacher made an inappropriate comment like in October, and it was the first time in like 18 months he'd said something inappropriate. But going back a couple of 3 years, he had been reprimanded for inappropriate comments. 100%, you don't get a completely fresh slate every year. You don't get to drop the F-bomb on kids once a year. And as long as you didn't get fired that year, you get a fresh start. That's just not what the law says. So that, and I always believe that, but it's nice to have the Supreme Court say that.
Not a bad argument in that we're canceling the contract for this year, right? Your contract is a 1 year. It hasn't renewed for next year. Last year's is over. So that's, but anyway, yeah.
I always thought it was a stupid argument,
Yeah.
but yeah. And then I read this out loud in my car because the Supreme Court just hammers him and says he was incompetent, he neglected his duty, he was unprofessional, he was insubordinate. There is more than sufficient evidence to cancel his contract. So. Okay, so here's some just good language from the Bridgeport case. This quote is exactly what we were just talking about. The board can consider all relevant conduct when determining whether to cancel a contract. It doesn't just have to be the stuff that happened this year, and it doesn't just have to be the stuff that you were the principal for, right? It can go back to prior administrative teams.
And I would guess that's not going to be limited to cancellations. They'll apply that to non-renewals and terminations
Yeah.
also.
So one of the things that they didn't raise that they should have is that Rule 10 says you must include all of their deficiencies. We've not yet had a lawyer raise that issue. I probably shouldn't have just said it out loud on something that's going to be recorded, but eventually, you know, I think that the all language in Rule 10 conflicts with the Supreme Court's opinion here, which says, if you heard him say something that you didn't put in a document, that doesn't make that inadmissible. The board should be able to consider that just because it wasn't included in the list of deficiencies.
I'm not worried about that. And this is especially true when the past conduct is intertwined with the conduct thereafter and deteriorating job performance. So this is why I'm not worried about that language in Rule 10, because it's all going to be part of one big ball. And whatever they did wrong this year, we're going to document, and then we'll pull in the other stuff and say that it's intertwined. That's at least my game plan moving forward. When it's necessary to think about the prior stuff, understanding and evaluating the reason for the cancellation now. That's another reason to be able to pull in old stuff. And again, I think that rest gets to a kind of argument that this is the whole story that you needed to hear. It makes sense of the Supreme Court, and we're going to be able to use all of that stuff.
All right, we're going to go back in time a little bit, going back 40 years. Shortly after the Tenure Act was adopted, they had a trio of cases that gave us some guidance that are still useful today. In Sanders, we had a 7-year PE teacher at South Sioux. The evaluations were always good or excellent until the 75-76 school year. And then we had a whole 2 categories that were marked needs improvement: classroom control and student participation. You'll notice here it says the board voted to consider termination. And as we went through that statute earlier, it does say the board or the superintendent or the superintendent's designee. It is very unusual to have a board vote to consider the termination of a teacher. That was probably a bad sign from the get-go. That essentially meant the administration maybe wasn't on board. And so lesson to learn there, especially for the attorneys. So at the hearing, we had the superintendent testify. The superintendent said, well, I never evaluated Sanders, but I did see that she wasn't present to supervise the drill team a couple of times, and that was one of her extra duty responsibilities. We had the assistant principal, and again, assistant principal didn't evaluate either, but you know, sometimes I had to discipline her students because she wasn't doing it, so that happened maybe a few times. Then we had the principal, and the principal is actually the one who evaluated the teacher, and he had some I guess, relatively minor complaints, nothing major, stuff that easily could have been remediated if the teacher had ever been told about the problem. But the important part here is the principal, the one who actually evaluated the teacher, recommended she had to come back. It's not that bad. I mean, these were minor complaints I had. Bring her on back. Board ignored that and fired her. Again, the board is the one that was driving this train. And so the Nebraska Supreme Court said, well, wait a minute. We got a teacher who didn't violate any rule, didn't violate any directive from anybody. No area of performance was rated as unacceptable. And we hammer on this one.
Yes.
We don't care what your evaluation instrument looks like. And this is why we hammer on it. Are you willing to check the box that says, no, they aren't good, they're terrible, they're horrible. Whatever that rating is, are you willing to check that box? This is why. I
want to jump in here. First off, if you've been doing this for a long time, I cannot recommend enough going back and refreshing yourself on these things. Every time I reread these old cases, like we talk about them, but we forget like how clear they are. And right here, this last bullet point that Steve has pulled up on the screen, we have now, again with Danielson and Marzano, there's like needs improvement, basic, proficient, and exemplary. And we have boards that have said in their policies that basic is not good enough. I hope that will carry us home. But in Sanders, they specifically said you had to mark unacceptable. And so if you have a 4-part rating scale and your board has said the first 2 aren't good enough, but one of them doesn't say unacceptable, I'm worried that some enterprising lawyer is going to get into Sanders and say you have to check the lowest box.
In this case, Sanders was not performing below the standards required of other teachers. So again, we were comparing them to the other teachers. The next one we had, the very next year, we had Davis. Davis was a tenured teacher at Callaway. The administration in this case recommended termination, and the board terminated after a hearing.
And the true reason, if you read the case, that they terminated him is because he had really bad BO. Yeah. I believe that's a big part of it.
Actually, that was Hollingsworth, not Davis.
Sure.
Yep. But at the hearing, we had the superintendent, and again, in this case, the superintendent personally observed the teacher. Teacher lacked organization, lacked control of the classroom and students, and had poor planning skills. And the superintendent's recommendation was this guy should be terminated. Principal, again, personally observed the teacher, did evaluations. There's a lack of discipline, lack of organization, and said terminate. There was a whole slew of other witnesses. They were all in favor of Ms. Davis, saying you should bring her back. She's very good. Nebraska Supreme Court said this is not the Sanders case. Here, the expert witness charged with the duty of evaluating the performance of the teacher testified that she was not meeting standards. This is why when we go to a hearing, they'll bring out a lot of parents, a lot of former students, a lot of people say, oh, this teacher was the best thing since sliced bread, and but for her, I wouldn't have gone to Harvard and cured cancer and done all these things. It doesn't matter. They're not experts. You guys are the educational experts, and the court has said we need to hear what the educational experts have to say, and they're going to give your opinion a great deal of weight. These other people may have been wonderful citizens, but they didn't have the qualifications to evaluate teachers, and so they're going to factor that in when they're considering a board's decision. Both administrators said the teacher neglected her duties. Expert opinions were sufficient as a matter of law. So clearly, you guys as the experts, that's why we want to get your opinion. We establish you as experts, and then we get your opinions and the evidence based upon what that information is.
Now, in an actual hearing, I'll tell you the worst objection of my life I made in a hearing in Hemingford, where a bunch of parents had shown up and they were talking about how awesome the teacher was. We had it in spades with the principal, who had done a great job, and the superintendent, but the parents all were talking about how great the teacher was. And I stood up and said, objection, they are not experts, they are just parents. And the whole room was like, woo. So we will not probably say that out loud at a hearing, but that's why we don't really go after the parents hammer and tongs, because legally their opinions just don't matter.
Now we have
Hollingsworth,
a couple years later. Again, another tenured teacher. This one's from Alliance. He received good evaluation. Just didn't fit in. It was kind of odd from what you read in the opinion. He had a conflict with another coach, but that was later in his tenure there. The students harassed him a bit, and that essentially was, as we'll get down here, really, it did come down, as Karen said, it's his BO and bad breath. And it turned out he had some problems with his teeth, had to have $1,500 worth of surgery back in 1981. And so that's what it was blamed on. But everybody complained about him. So the principal goes to him in January and says, you know, it's time for you to go. I need you to resign. He refused to resign. After this resignation, everything increases. Basically, we had no evidence up to that date. Now, all of a sudden, it looked like a witch hunt. Everything, there was an increase in his discipline. They complained about the way he disciplined students. They did a student survey. And basically, the principal admitted, yeah, the kids probably knew what the purpose of that survey was when it was issued. And again, after that 131 date, and complaints about his personal hygiene. The Nebraska Supreme Court said, no, wait a minute, all of his evaluations were good. There was absolutely nothing in the record to reveal what prompted that January 31st request for a resignation. But it says from that point forward, witch hunt. That's what we had. We had a systemic and diligent search for evidence which would justify the decision that had already been reached. So for whatever reason they decided he had to go, they pretty much trumped up the charges. The court saw right through that, and they said, that's not going to fly here. And he was reinstated. So you have, the lesson to learn here is do your homework, do your work up to that point in time. If they had truly evaluated him and mentioned the awkwardness and mentioned his difficulty in having relationships with students and relationships with parents, there would have been a history of that over the 7 years. That could have been used. But in this case, they just didn't do that, and they tried to railroad him out of town.
This is why you can't counsel them out until you've got the goods on them. Because if you have that counsel them out conversation and it fails, everything you do after that conversation looks like you made it up.
Okay, so the Schultz case, this is a really good one. If you're a superintendent there and you want to give your evaluating principals some continuing ed, reading these cases would be a really good idea. Like Karen said, when you go back and read them, you take little nuggets out of them and you put yourself in the mind of an evaluator, and you're like, wow, that would be important to know that that's how our Supreme Court thinks of these things. So this is an elementary teacher in Fremont that essentially had worked for the district for a little while, took a break, and then came back and had a 10, 12-year tenure then. And basically, everybody concluded that this was more or less, I would consider her an old school teacher. I don't know what old school meant in 1982, but
It's not that old.
But you had the superintendent testify that she basically did not meet the standards of competence. You had the elementary teacher and the principal, or a supervisor and the principal, testify to the same thing. She was a poor communicator. She was too gruff. She gave too much homework. You had a bunch of parents that testified essentially that she was such a bad teacher, she was too tough on the kids that they developed anxiety, right? So this is the millennial parents, helicopter parents case before we had millennials and helicopter parents. But basically, this is all that happens at the hearing. It's made to be a competency case. It's to some extent a little bit like the last example that the hypo that we talked about with Sherry, where she's really hard on the teachers or on the students, and they bring the case saying she's not meeting the standards here in the district of competency because she's not effective. So they go all the way through. She ultimately ends up getting terminated. They appeal it to the Nebraska Supreme Court. And essentially they said testimony of the parents is insufficient, even though they brought in medical complaints to say that their kids had suffered from nerves. This is back to Karen's concept that the opinions of the parents with respect to her competency as a teacher simply are unsupported conclusions at best. They are not the professionals. So when you see the court talking about it in those terms, it makes sense then. You have to let parents testify, of course, but what they really want to know is when they view the facts, were the experts that evaluated the teacher in agreement that she was incompetent? And here, what you have is the court saying essentially she received all above average ratings during the time she taught, or that she taught. So we do not see, in fact, the court says we're at a loss to see how the school board and the court below us could have found any basis in the record to say that she was not competent, did not meet the standards of competency. In fact, the court concludes by saying, Schultz is an old-fashioned teacher. Perhaps such teachers did not win popularity contests, but neither can they be said to be incompetent. Teachers are not required to entertain their students, only to teach them. So in other words, this notion of we have a bunch of parent complaints and nobody likes this teacher isn't necessarily good enough. The last case we're going to talk about is Johansson. And if you are an evaluating administrator out there, I would read the Johansson case. We will post it. We'll make sure that Sherry posts it up there. We've got a copy of it that I used actually recently for a school or an education law class. And it goes through a ton of these things we've already talked about. This is a tenured special education teacher in North Platte. There's a whole bunch of bad stuff that it's alleged to have happened essentially while Johansson was a teacher. Tying the student up with an extension cord, referring to students as an idiot, physically and verbally assaulting other students, having kids in the class hide from this student that he excluded from the class, putting soap in the student's mouth, shaking students, and all sorts of bad stuff. And the board terminated essentially for unprofessional conduct. The Nebraska Supreme Court says, when we're evaluating this case, essentially we're going to defer not only to the expert opinions, but also to the decision of a school board. If we were at a court trial, not a school board hearing, and a judge couldn't say that their reasoning, their basis lacked any evidentiary support, that's the only time that a judge could take over and substitute his or her opinion for a jury, basically. That's the standard that we're going to review these cases when they come to this on appeal to the courts. Admission of hearsay evidence is not an error. This was a big part of it. And this is where we say, we talked about the rule earlier, that although hearsay is supposed to be given less weight at these hearings, it is admissible evidence for a board to hear. What will typically happen in a hearing is there will be the introduction of hearsay evidence. So you're a principal testifying. And what did little Johnny say to you? Little Johnny said that he wrapped up Timmy with an extension cord. Did you see it? No, right? So you'll get an objection there. That's hearsay. It can't come in. And we'll go through the whole song and dance, and the hearing officer will say, okay, Board of Education, I have to admonish you that you're supposed to give this a little weight, but it is admissible for you to consider. That's where this rule comes from. So this notion of, a kid writes a statement or a kid tells you something. We don't like to call students as witnesses, and part of the reason that we can get away with that is because what that student told you can be admitted at the hearing. And then finally, to determine whether a conduct is unbecoming, even though not in violation of any specific rule or conduct, we look to the opinions of educational professionals and school teachers. So other teachers are normally expected to be able to determine the type of conduct which constitutes unfitness to teach. This is important because going back to the Bridgeport case, the Robinson case that Karen talked about, he called a whole slug of teachers to testify on his behalf. And the way that we dealt with the teachers was to say, you're a teacher, you hold a certificate, correct? Yes. The Johansson case then renders that teacher able to give an expert opinion, not that it gets as much weight as, but they can give an expert opinion just like a superintendent or a principal on what constitutes professional, unprofessional, and all those things, which is why we say you should have teachers document in writing while they still have the spine to do it before 6 months before a hearing, what the conduct is that they believe to be unprofessional. And so those teachers at the Robinson hearing all testified that yes, this, that, sometimes they disagreed, but basically all of this stuff is unprofessional conduct. So any teacher that they want to call in support, the NSA wants to call in support, our cross-examination tactic is to say, okay, do you think this is unprofessional? You sort of box them in front of their boss, right? In front of the board and the administrators is saying, yes, it is, no, it isn't. So anything I'm missing from those? I went through those really quickly. Again, we'll post them. The facts are really important to read through, obviously, in these cases. And I think they're good reminders of a lot of this stuff.
The lesson from Schultz and Johansson is you have to have the starch to mark does not mean.
Exactly. The lesson from all 5 of
Yeah.
those cases is that really, yeah.
So circling back to Sherry, I believe this is probably a legally sufficient case. I'm not worried about getting reversed on appeal. This is a question of, do we have the political support? She's won state softball. She's been there forever. She probably is really deeply embedded in the community and has taught Vacation Bible School with board members or whatever. So you're going to have to ask yourself that. It would be awesome if we can get other staff members to testify or to at least get agreed to be listed as witnesses so that we can show some unanimity. But I would posit this other thing. Sometimes I have administrators say, I don't want to come in and swing the hammer my first year. That's going to hurt my the climate in my building. The flip side is you only have so long to establish that you're the new sheriff in town and what used to be okay is no longer okay. And your board just hired you, so they're likely to support you because they want to give you the support they need. You need to get started.
And one of the things we're going to probably tell you in this case, if you call, is, so how much are you talking to the board about this new culture, right?
Yeah, that's right.
That's why I think in your principals report, it's not wasted effort to talk about these new cool programs that you're implementing. You're not wasting their time. This starts to build some cachet with them so that when you come in and say all that stuff that I've been telling you about for 11 months that I've been working on, she cuts against that very, very clearly.
Yeah, and I would also start telling the board early on that all the culture changes you're making are not necessarily uniformly supported by veteran staff. And most of the time your board knows that is an issue and they probably can guess who it is. But so then you've kind of got them, without saying it's Sherry, you can say, some of the long-term staff are not necessarily supportive. You get the board mentally down the road, and then when it is Sherry, they kind of have already gotten emotionally invested in making some changes, hopefully.
Yeah, we're going to skip, we have a few other issues just in case we needed to fill time, but I think you'd probably, unless you want to say anything on those.
I was going to say, I thought we'd go here, just and see if we have anybody text questions.
Okay.
That's what I was going to do.
Here, you want to go back to
Go back to what,
just the
this?
first slide with the numbers on it? I think hopefully everybody, if somebody's got one of our cell phones, but if you have any questions,
I'm going to
send
go
them our
back to
way.
that slide where we show. Like the current slide, here we go. Now I need to share the screen again. Okay, so here are our cell phone numbers if any of y'all have questions. It is 11:56, so if you don't have questions, we don't have to hold you hostage for 4 more minutes.
I got one question. Do you have any?
Yeah.
What should the counseling out conversation sound like? Really good question. I mean, you've heard us sort of push back against it a little bit. Very effective administrators use it effectively, but that's because they know they've got the cachet in terms of relationships and documentation and everything. What I think it looks like is you've done an assessment of the legal sufficiency of the case. You've talked to the school lawyer about whether you could proceed, because the one thing you don't want to do, unless there's, we'll talk about it, maybe, I guess, an exception to that rule in a second, but I think the one thing you have to be able to do is walk in there and say with credibility, I think the board's going to support me because I intend to make a recommendation. Now, if you want to handle this a different way, if you're thinking it might be better professionally for you to resign, you sure can. I have been, because the union has been attending more of those meetings, I've started to tell schools I think that's a good thing if they bring our union rep with them, because what you can't necessarily do with as much credibility as their representative is tell them things like, yeah, no, she was serious when she said that if any school calls after they give you notice, they're not going to be able to talk to them because they have a personnel case that they can't discuss. They're very serious when they say that if you apply at another school, they may ask you if you've ever been given notice of termination or non-renewal or cancellation of your contract. So some of those things can be effective in terms of, in telling them how, how it's going to impact them if they request a hearing. But I always say don't start that, don't have that conversation until you know you've got the juice to go through with it, and that you, if you're the superintendent or if you're a principal, that your superintendent would support you actually doing it if you say it in that meeting and they don't want to resign or move on.
So just think about the hypotheticals that we've had. If you have that counseling out meeting with Cody or with Sherry and you say, look, I think maybe you should think about finding something else because I'm not sure you can stay here. And Cody says, screw you, my father-in-law owns half the county, and you don't follow through on that threat, Cody is going to run roughshod over you for the rest of his career. It is better for you to not articulate that threat if you can't carry it out than for you to say that you're going to do it and then not do it. So I think it sounds something like, you know what, Cody, I've looked over your evaluations for the last 3 years. It looks like you used to be effective in the classroom. I think you can do it. But if you look at the documents that I put in there recently, it shows your attitude is changing. It seems like you might not be happy here. So if you aren't happy here, I would really encourage you to find someplace else where you can be happy. And if you let me, I can help you find that. If you don't choose to find other opportunities, I think I'm not going to have a choice but to recommend that the superintendent terminate your contract. I've talked to her about it, and she is supportive of us going forward. I would rather not have that blemish on your record, but that's your choice, not mine. And then I wouldn't give them a ton of time to think about it. I think over the weekend is enough. If they offer to resign then and there, for God's sake, take it. Have them write it down right there. Do not say, in the name of all that's holy, don't say go home and talk to your wife about it, or go home and talk to your parents about it, because the family is going to kind of convince them to go forward. And sometimes the local association thinks a hearing will be fun, and they will encourage the teacher to go forward when they really shouldn't. So if the teacher starts getting cold feet and wants to resign, take it right then and there.
Which is, again, this conversation with Cody only works assuming you've laid all that other groundwork.
Yeah.
You've met with him about what the other staff members are saying, about what he mentions in the teacher's lounge and at the bar on Saturday night. I mean, all that stuff has to be in place or you're just talking into a brick wall.
The other thing we do with Sherry is we say, hey, Sherry, you've been here a long time and you've done great work. We have new expectations. So I have this 5-point improvement plan ready for you. It requires you to read 15 books and go to 2 workshops. I believe in you and I think you can do it. If, however, at this stage in your career, you don't want to do that, you are eligible for retirement, but those are your choices. Get better and do all this work, or ride off into the sunset and we'll give you a nice going away tea. But you don't say you're too old to do this, or you don't want to do this because you're going to retire anyway. You say, I believe that this will help you, or you can retire. So you put that choice out there on them. Don't say anything like old dogs, new tricks. Don't say anything that would let Sherry sue you for age discrimination.
Yeah, nothing discriminatory. I don't like threats. I like presenting options.
I do too.
Yes, exactly.
That's really what you're doing, is telling here. And as Karen said, no matter what the context is, you have to be willing to follow through on what it is you say you're going to do. It's not a threat. It's just, here are the consequences of your decision.
Yeah. And we always ask in preparation for those conversations, what do you think the teacher's going to say or do? And then that can kind of inform the strategy. So the short answer to the question, what should the counseling out conversation sound like? It should sound like exactly what would be most effective with that teacher based on what you've done. There are certain things that I think are brought up in most of them. And if, especially if you're somebody who's an administrator that builds good relationships, you can say with credibility that professionally, I think this is what this would mean for you. But yeah, I think we would recommend tailoring it to what that person's going to think.
Last thing I'll say, and then I see it's 12:01, we'll let you go. If you're talking about a letter of recommendation, which you don't want to say, I'll give you a good letter of recommendation now, but if you ask for a hearing, I'm gonna punish you. You want to say, at this point in time, I would be able to give you a truthful letter of recommendation that emphasizes your positive attributes. But after we move forward, the lawyer, I don't think will let me do that for you because we would have other considerations. So you're not going to lie in one letter or the other one, but the first one, if they resign, you'll give them a letter that emphasizes their positive attributes, which could be as simple as she came to school most days and she was always wearing clothes. I've written those letters. I don't ever want you to lie. Okay, it's 12:02. You guys have been great. We will send out a little survey when we send out the link to the recordings and stuff. I say this every time, but I really mean it. We're trying to make these good. I want them to be excellent because I think this is the future. So we crave your feedback. So please take the time to fill it out. And then feel free to share the recordings or rewatch the recordings and let us know if you find those helpful. Thank you all. And oops, I think we're going to discontinue.